As was mentioned, my name's Patrick Rodgers. I'm Special Counsel here. I work with Brian Ambler, who's a partner in the commercial team. And as part of our practice, we provide procurement and tendering and probity advice to organisations, including government organisations, the Commonwealth of Australia, Department of Defence and DFAT and Australian National Audit Office, state government as well, and local government, state government in New Zealand, also state governments of Queensland, Victoria, South Australia, and also in New Zealand. Brian's not here today because he's meant to be in New Zealand. He's of course now not in New Zealand. However, he's engaged in a lengthy teleconference on that subject matter, as that's how we're conducting that at the moment. And as I said at the outset, we are procurement and tendering lawyers. Now, just as a bit of a guide, I know some of you, who here is routinely involved in procurement? Okay, all right, well then we new for some of you. Who's involved in procurement now that hasn't been involved in procurement before? Okay, and who here is from government? Okay, all right, thank you. That just helps give a little bit of an idea of the background of who the audience is. Now, in the course of procurement and advising and tender, you'll hear us often refer to a principle to probity. Now, what is probity? Probity is essentially honesty and integrity in a process, and importantly, the ability to demonstrate the honesty and integrity in a process. And I'll explain, and it'll become evident why that's important. As procurement lawyers, and as far as probity is concerned, we are concerned with systems and processes and demonstrated compliance with those systems and processes. We're not concerned necessarily with the outcome of that process itself. We don't mind who have a preconceived position on who wins the tender or what the outcome should be. And it often surprises our clients on that. We spend a lot of time checking with our clients to make sure that they have processes in place. So essentially they say what they're going to do. They have a system in place to say how it is that they said that what they were going to do. And lastly, that they have documentation in place that's able to demonstrate how they did what they said they were going to do in the manner in which they said they were going to do it. Simple, yeah? Probity is simple. We're just checking boxes. Okay? Do what you said you were going to do in the manner in which you said you were going to do it. Doesn't sound too difficult, does it? Now, why is it important to us as lawyers? Well, has anybody here heard of the Hughes aircraft case? I'll give you a little, okay, one at the back. I'll give you a little bit of a quick summary of that. The Commonwealth was going to tender for air traffic control systems. Quite a big contract across the country, very important. All right, you've got to get this stuff right. They were down to two tenderers. One was Thomson's Radar, who was the incumbent, currently providing the services in Australia. The other was Hughes Aircraft, part of the Howard Hughes empire back in the day. Now, they provided similar services in other areas and jurisdictions. So they were down to those two. And they entered, and the Commonwealth provided the two tenders with what we would now call a conditions of tender. It was maybe a bit thinner of what for the sort of thing that we'd expect for that contract now. It was about 5 or 6 pages. Importantly and relevantly, it said at one particular point that responses would be evaluated with the following criteria in the descending order of importance. All right, and this is important. The descending order of importance was, firstly, technical capability, obviously very important for air traffic control systems. They're the things that make sure that your plane lands safely on the ground at the appointed place. The second one was past performance, similar, linked to the first, obviously very important. The third most important was price, and the fourth was something that we would now call Australian industry involvement. I'm paraphrasing what they are, but that's roughly what the criteria were. So they went out to tender, and they got the tenders back. The evaluation committee evaluated the tenders in accordance with those criteria that just stated, and they said, well, first criteria, technical capability, not too much difference. They both get a tick there. Past performance, Thomson's does it here, Hughes does it in another place. Both similarly sort of tick, not too much to split in those first two criteria. Third one, price. Hughes was $20 million cheaper. To most people, $20 million. Now, these are expensive contracts, right? Well over $500,000, and for a lengthy period of time. So $20 million, maybe not that much proportionally, but still a lot of a high amount of money to most people's way of thinking. Third one, Australian industry involvement. Well, Thomson's was here, so obviously they were established in Australia. Hughes obviously said, well, which is not unusual in these sorts of circumstances, we're not there, but if we win the contract, we're going to go, set up there, establish the base and so forth. You might have, there's similar sorts of issues currently with the submarines contract and the amount that's meant to be performed in Australia, although that's more by subcontractors than BAE directly, but similar sort of principle. We're going to do some of the work in Australia. So, Thomson's got a slightly bigger tick. Hughes still got a tick though, and the Tender Evaluation Committee recommended Hughes because, well, $20 million is $20 million. That decision went up. Now, Thomson's, it happened to be an election year. Thomson's was based in a particular state where this sort of thing is often relevant. Anybody want to hazard a guess at which state it is? No, close. South Australia. And then, as now, South Australian senators can be and representatives can be very vocal in their representation and interests of that state, particularly in relation to the retention of industry. There was the number of representations made, which is right and proper. They're there to advocate the interests of their states and their constituents. But in one way or another, pressure was brought to bear on the Air Services Board, who returned the tender to the Evaluation Committee, saying we don't consider that you gave Australian industry involvement sufficient consideration in the matter. The evaluation team went and re-evaluated it, looked at it again, and came up with essentially the same result. We've looked at it, we've given Australian industry involvement, the fourth most important criteria, more consideration, and we still recommend Hughes as the preferred tenderer. The Commonwealth Government and Air Services Australia promptly awarded the contract to Thomson's. Now, a couple of things about that. In government processes, at the end of the process, you often provide a debrief to the unsuccessful tenderers and the successful tenderers as well. In this case, people attending the debrief with Hughes, none of them are involved in the evaluation, which is often, can't give a lot of detail when that's the case, and a lot of support. And amongst other things, they told Hughes that price had not been a significant difference and factor. Now, in Commonwealth and in a lot of government contracts, people know the values of the contracts, they're published as a matter of a requirement of law. So Hughes did some digging. There's some other things that came up, and they applied for early discovery and got the documents that basically laid out what I've just told you. And they promptly sued the Commonwealth. Now they sued for under three main heads. One was for misleading and deceptive conduct under the then Fair Trading Act, now the Australian Competition and Consumer Act, and the Australian Consumer Law at Schedule 2. They sued for estoppel in equity, basically saying that they had relied upon the representations in the documentation to their loss. Some of these in tendering for these services, and they therefore suffered loss. And thirdly, and most importantly, they sued for breach of what's called the process contract, following a line of cases coming out of the UK, Canada, and most recently New Zealand, being the Pratt Contractors case that's up there. And what that doctrine essentially said is that the tender put out by the tendering organisation essentially established the rules and for that tender that were binding on the tendering entity. Tenderers as well, because you usually always have conditions that apply to the tenderers, but they're applying on both parties, and essentially that having said that you would be evaluated in accordance with those criteria and that manner, they were obligated to follow those rules. So they ran the case on that basis, and they were successful under all three heads. Now, anyone that has a guess why? Anybody want to tell me why the last one was important? Okay, so under the first two, they would probably have got the cost of tendering. Remember, under the estoppel, that's the loss that they suffered. They tendered, well, they would have lost that. What do you get if you have if you're successful in establishing a breach of contract? You get damages. The principle for damages is to put you in the place as if the contract had been performed. Two tenderers. Their argument was essentially that if you had performed the contract, we would have been the successful tenderer and won the tender. And if we'd have done that, we're entitled to profit. Okay, they also had another element to their claim. If you represent in Australia in those services, you're a world leader, so you also have the potential to market your services overseas. So they had some expectation loss as well from there. So that considerably increased the damages that they were claiming. And the court found in their favour. It was settled, damages were settled, and it was somewhere between $40 and $60 million that were paid to Hughes not to perform the contract. They were already paying an additional $20 million to Thompson's to perform the contract. Costs to run a matter to the federal court. It's not cheap even back then. And of course, if you lose, you pay the other side's costs or a large portion thereof. So the Commonwealth spent something in the order of $100 million to learn the lesson that you should do what you said you were going to do in the manner you said you were going to do it. And that's the worst case scenario in the legal backing for where it starts as far as case law is concerned. I think we've covered that slide. We established the process, Hughes established the process contracts, the potential risks and liabilities of the procuring entity, the Commonwealth, the rights of tendering and can expect, and importantly, the potential for damages. Now, since merging through those are the principles of probity, which we'll talk to a little bit later on. Now, since Hughes, the process contract has been, Hughes has been followed in relation to the establishment of the process contract in all Australian jurisdictions, including in Cubic there and IPEX. Those cases are interesting in that they address attempts in part to exclude the process contract. And now what merges out of them is, and you will have often seen in your clauses, those of you who do procurement and tenders, there'll be something that purports to exclude the process contract. That's not fully tested and settled at Australian law. The case law suggests that clauses that purport to exclude the process contract that are inconsistent with the remainder of the document may be unenforceable. So similar to any other contract that you're looking at, ultimately the court will look at the document and decide what the document is. And so for those of you who are familiar with other things that are purporting not to be agreements, the risk is always, of course, that they may be interpreted as that if the intention is that they should be binding. The other thing that they established is that you essentially, if a procuring entity reserves rights to itself, it can follow those rights. So that's not inconsistent with the process contract. Of course, again, you're saying what you wanted, that you can do the following things in the contract document. You're entitled to do that. There are also other issues addressed in relation to tying government or procuring entities to internal policies and processes. Again, they're not strictly part of a contract, are they? Because they're not given to the other side unless they're expressly included into the contract by the terms of those contracts. And perhaps one of the interesting things to arise out of them is there's no obligation to have a good procurement process. Both those procurement processes came under some criticism, but again, it came down to what you said you were going to do, rather than, oh, this was a great process. The decisions weren't challengeable on the basis that, oh, it could have been done better. They're not administrative decisions, they're commercial matters for the entity, so they're not challengeable on an administrative basis, which we'll talk to in a little bit. But you don't have to have a good process, but the process that you do is what you have to follow. In addition to the case law that we've mentioned, government entities have obligations under a regulatory framework at all levels here, and that's increased in recent years. One of the issues that comes up in these cases in the early years is the jurisdiction and the ability of the court to hear the matter. Remember, it's not an administrative matter, so it's not subject to administrative appeal. So what's the basis of jurisdiction in considering a commercial decision of a procuring entity? That's in the Commonwealth, the Government Procurement Judicial Review Act, and in New South Wales, the enforceable procurement provisions have come in the last 24 months, in part in response to, funnily enough, international trade and treaty obligations, notably the Comprehensive and Progressive Agreement for Trans-Pacific Partnership, which is basically the former Trans-Pacific Partnership, absent in the US, who didn't sign, but it has a much longer name now. And part of what those obligations are that government would have an ability for aggrieved, notionally suppliers from overseas who were aggrieved by breaches of those treaties to progress their cases for breaches of, in the Commonwealth's case, the Commonwealth procurement rules, in the stateless case of breaches of what is now the enforceable procurement provisions. And so now there's established at those a case where, in the New South Wales context, the Supreme Court can hear cases for alleged breaches of the enforceable procurement provisions that have come in. So they have legal obligations. Now, I've noted that not all of you are from government organisations. Remember, absent that, there are still issues, even excluding the process contract and reserving rights to yourselves. There are still issues relating to misleading and deceptive conduct and potentially estoppel. Oh, by the way, if you have any questions as I'm going through, I'm happy to take questions as you go. Any questions so far? Procurement processes. So pre-procurement activities have become more important these days. Now, my background, I used to work for the Department of Defence before crossing over to the dark side of corporate law. And when I started with Defence, you'd run a process and everyone would say, a procurement process, and people would say, for God's sake, don't talk to industry, probity, which we would argue is a misunderstanding of what probity is and how probity should work. Probity should not fetter and hamper a process if it's run and applied properly. But that was the understanding at the time. For God's sake, don't talk to industry. You'll have a conflict of interest. You'll become biased for a particular supplier. Don't talk to that. Now, if you're dealing with highly technical, that might be fine if you were buying paper, and the paper was fairly standard. If you're dealing with highly technical subject matter that, frankly, you may not be fully across, that highly likely in defence, in other technical engineering fields, the experts are in industry or have come from industry. It doesn't make sense to exclude them entirely from the early process, and it can be managed with probity within the requirements of probity, so long as it's managed well and appropriately. There's an example of it not being managed well and appropriately from the Commonwealth. Again, it was an air contract. It was air services to the Mid East area of operations, and that was basically, it's a wet lease flying to the Middle East, and then it was Afghanistan. So a contracted provider flies those flights for defence. Now, what I would tell you in the RFT, and this is the importance of the early stages and the effect because it can have on probity, because remember we said the Hughes aircraft was at the end. If you have if I say that the requirement for the payload door, so the door that goes into the aircraft where the loading goes up, changed by about 15 centimetres, the size. You needed a size that was 15 centimetres wider. No big deal? Well, if I tell you that the incumbent's aircraft are no longer fully compliant, but a competitor's is, any issues there? Anybody knows what it costs to modify an aircraft to make the payload doors 15 centimetres wider? It's a trick question. You can't do it because you actually affect the structural integrity of the airframe. Okay, you would have to send it back to the manufacturer, and even then it couldn't be done. You wouldn't be certified. It's not possible. So it's a considerably competitive advantage. What if I now tell you that someone that was involved, that the organisation that was making that specification had somebody attached to it who had worked for the competitor, who was ultimately successful, by the way? Any issues there? No? None? And had a contract company that would go on to subcontract for that competitor when they were successful for that contract. All happened at the beginning in the early stages of procurement, which is why you've got to establish your framework and probity requirements early, and they can apply to even early industry engagement and requirement specification. Okay, in pre-procurement activities, consultations, meeting with industry, generally you want to be as inclusive as possible and have a process for basing that selection. We seek to exclude the process contract by saying it's not part of the procurement activity at that stage. Key to that is not to down select at that stage. You're just essentially information gathering, but you still have to have processes in place to manage that side of things. That case that I just mentioned didn't go to court. Can talk about it because it was the subject of a Senate estimates investigation. If you work for defence, you hate that almost as more than going to court. It went through, went through one internal investigation, 3 external investigations by very expensive accounting and law firms before going to Senate estimates, and it took 3 years to come to the conclusion that there was not a sufficient basis to overturn the procurement decision because there was no actual direct proof or connection that this individual had had anything to do with the specification. It was just all a result because they hadn't managed it properly at the start to establish that and ensure that they'd managed conflict of interest appropriately. The length of the contract in question was 3 years. Most of you will be familiar with other types of, with the more, the core procurement activities of request for tender. They go under lots of different names these days. Request for tender, tender processes, RFIs will generally be in pre-procurement activities. Sometimes they're called request for proposals. Sometimes we have clients, government clients say, oh no, it's not an RFT, therefore the rules don't apply, it's an RFP, or some other animal. No, it still applies. Then you have evaluation, again, remember in accordance with the criteria, and the reporting of outcomes, or usually through an evaluation report, source evaluation report, again, various different names to that. Increasingly, again, and it's in part of the, it follows the line of the increasing demand for pre-procurement activities, is the, that as part of these processes there'll be something like, again, it comes under various names, offer definition and improvement activities, where you'll shortlist down to a number of suppliers and engage in further negotiation on them to improve and refine the offer. Because the offer that you've got through the process up to that stage isn't perfect. Local government has some constraints in dealing with that because they're managed slightly different, and if you work in local government, your abilities are to accept or reject a tender. That's it. You can't negotiate. You get to the end, you evaluate, essentially under Section 55 and the regulations, you accept or reject, which obviously can lead to a less than perfect outcome. Of course, if you do reject, you can then have another process to negotiate with another party once you've rejected. But you go through the process, reject, and then negotiate with a party. But you go through those processes. Again, they tend to be probity hotspots, particularly where you have parallel negotiations and BAFO as part of those processes. Heightened risks tend to be in relation to confidentiality. You can't carry in either you can't obviously directly give papers intended for one entity to another entity. You also can't or shouldn't, whether deliberately or by accident, transpose the idea of one onto the other. So if you have one party that you're dealing with who has a really good idea, and the other side is really good, but it'd be even better if it had that idea, you can't take one from them and give it to the other, for obvious reasons. That would not be considered to be fair and impartial, in addition to the risks of breaches of confidentiality and intellectual property that might also accrue. And then lastly, negotiations. What the involvement in negotiations at that point tends to be in relation to making sure, obviously there's the legal side of things as far as the contractual side of things go, but it's also making sure that what's negotiated reflects the outcome that was submitted in the tender and the evaluation. So obviously if it changes so dramatically that the evaluation and submission was no longer relevant, it becomes a question of, is that still valid, or could somebody have given you a better product if that had been the actual framework that had been put to market. So you want to make sure that it's actually consistent, such that the initial offer and evaluation remains substantially the same and relevant. We work as probity advisors and as probity auditors. Probity advisor, you come in and advise during the course of a project, ideally at the beginning. It's always easier if you get to start from the initial documentation and ensure that that's all in place, rather than try to fix anything up or review things in arrears. And you can provide advice to the project and to other inquiries to make sure that procurement requirements are met and that the requirements of probity are managed properly and appropriately. It's ongoing, and we often will check in and provide interim probity reports at various stages of a project to say that yes, they've complied with the principle of probity, here were the issues that may have been raised, this is how they were addressed satisfactorily, etc. Probity auditor, you come in usually at the end of a process, after a process has been run, usually as a result of where a complaint or issue has been raised, you don't necessarily give advice on on how to remedy that, because it may not be something that's remedied, but you do an all-in review and you give a report of what the probity position is on that particular matter. When you get instructions on that, often you don't get told what the actual genesis of the requirement is, and it will come out through the investigation of the papers and the documents. Ideally, of course, it does help if you're told up front that there's a complaint on this particular point and matter, because you can focus your investigations. But sometimes there's a reluctance to disclose that at the start, although it usually becomes very evident in the documents. One of the things that does get resisted at all the levels, of course, is tenders that aren't successful, particularly in big tenders. So some of these projects you work for, so we mentioned the air services tender, as in for the Hughes aircraft one, some of the bigger government technical ones. Those processes, if you're going through first and second pass at Commonwealth, even some of the bigger state ones, they can last for years as a procurement process. And when we mentioned before that they would have probably got just the costs of tendering, that can be substantial. So on a large matter, that can take a couple of years. And technical teams, you can have 30 people on a technical matter for each tender involved in ODI for up to 14 weeks. Some of those people will come from at least interstate if you're working out of Canberra. Quite likely they'll come from overseas. So when we say you just get the cost of tendering, those costs can still be significant to participate in the process. So aggrieved tenderers, particularly those that may be losing contracts, and particularly where they're specialist contracts where there's not another market necessarily for them to go to, so they've lost a big chunk of business that they don't get back often for a long time, are highly motivated to raise issues and complaints if they possibly can. Now, having said that, the court has taken a dim view, including in Cubic, where that is the purpose of progressing litigation. And that was a factor in the Cubic decision. We've touched on most of these points. Impartiality and fairness. Basically, it's about trying to provide a level playing field. Now, that doesn't mean that people are necessarily required to unknow what they know as far as the procuring entity is concerned. But you have to be open to consideration of alternatives on a fair and reasonable basis. And importantly, there's generally a single point of contact. One of the things that we want to make sure happens is that all tenderers get information at the same time and get the same information. If they're getting it from different sources, of course, it can be the wrong information, even though how well-intentioned it may be. So there's usually a single point of contact in relation to projects, and that's where things are managed through. Conflict of interest. also need to be managed throughout the process. We mentioned the air services case before of the contractor who worked for a tenderer and also had a company with interest in the relationships. In some forums, there's constraints on the use of personnel and former personnel where they may have access to confidential information. And essentially what's required from the procuring entity is that people involved disclose what their conflict of interests are. So generally they can be managed one way or another. But the main thing is to know. Again, if you work for a government entity or in any position where these things are up, the best way to be able to deal with a problem is to be told, if somebody makes an inquiry, minister, media, whatever, is to be able to say, we knew about this, this is what we did, and this is why. And I had to do this, this is part of my job. And then the second, and the worst response is, we didn't know about that, we'll investigate and get back to you. Never goes over terribly well. Generally, people involved in the process should treat it as confidential. Now, that said, obviously it's not privileged, so ultimately, as you saw in the Hughes aircraft case, tendering documents or documents relating to a tender are discoverable and can be obtained. Always assume that everything that you write will be read by another party. Accountability and transparency, we've touched on the need to make sure that you document what you've done and why you've done it and how you've done it. And that's obviously to provide an auditable frame, a traceability in the event that there is any requirements to justify a process and decision. There's some further cases there which you can look up and go, or we can send you the case summaries if you like. Just write to us and ask for them. We'll send them in relation to procurement and probity. Again, the Problem Gambling Foundation of case, which also went to appeal. That was another case where the actual contract in question went for 3 years. The matter took 3 years to decide in the Court of Appeal. It's currently open for tender now. Okay. Any questions? Thank you very much.